look outside the system of a court? Many answers. There is no dearth of answers. Let's examine a few of them. Number one, and Nandini gave you a lot of facts on this, the court system is clogged. And a client asked me, how long till you get the first round of adjudication? I'm not talking about first appeal or second appeal or going up to Supreme Court. I'm saying first round of adjudication. The estimate I give is 20 to 25 years. Now, beyond a point, when you say 20 years to a client, the fact of the matter is it's their children that are going to be reaping the benefit of the award, of the decree, not them. The second important component, why you look at ADR and things like arbitration, is enforcement. An arbitral award can be enforced much faster and easier than a decree of a court. This is especially attractive in international contracts because all of a sudden, you're not just dealing with the local courts of a particular country, you're dealing across the globe. ADR can be confidential. You can make it confidential. This is important in today's world where people are very sensitive about certain parts of their contracts. So if you want a dispute resolution system that permits you that confidentiality, go for ADR. I think another way to look at ADR is the way to look at it in a cross-border scenario. Somebody sitting in India, somebody sitting in the US, an Indian party doesn't want to submit to the US court system. The US party does not want to submit to the Indian court system. In cross-border contracts, no party wants to submit to another person's court system. Neutrality and fairness is key. Arbitration becomes an attractive option in that kind of a system because it permits you that kind of independence and neutrality. Add to this, you can choose any kind of party autonomy that you want. You can say that the arbitrator needs to have a certain set of qualifications. You can choose who your arbitrator is going to be. You've got elements of independence and impartiality built in. You've got Schedule 5 and Schedule 7. In court, you don't have any of that. The matter gets listed before a judge, and it's your luck of the draw which judge you get depending on the sitting list at that point in time, and that can change from time to time. So all of a sudden, lots of attractive things going for arbitration. The problems that we see, and this is something you should acknowledge. As of today, arbitration hasn't developed the way it should have. When I say has not developed, what I mean to say is the lawyers practicing arbitration are the same lawyers who practice in court day by day. So they practice in court by day and they do arbitration in the evenings and on weekends. That's not the correct approach. You should independently be doing arbitration through the course of the day. Nandini touched upon this, but the reason I am pressing on this and fleshing it out a little more is to explain that we are seeing this change. You are seeing a younger generation that is doing only arbitration. You are seeing even seniors who are saying they don't want to do court matters, they want to do only arbitration. You are seeing the nascent stages of development of what we like to refer to as the arbitration bar. It's not formal in any way, but you're seeing it because how do you see it? You know which lawyers are only in arbitration. They say that this lawyer he's busy in arbitration, he will not be coming to court. You're seeing the development of this. And why am I pointing this out to you? Because as a future practitioner of dispute resolution, you can choose whether you want to be in court, you want to be a counsel standing up and arguing in court, you want to be a law firm kind of lawyer who advises on the strategy to be adopted, or you can be an arbitration lawyer. And the choice is yours. So keep your mind open to the various options that are available to you. What does arbitration need? Arbitration needs time, it needs dedication. You are seeing the new bar come up, but it requires discipline and dedication. Now, when I practice dispute resolution in a law firm. When a client enters, I don't know whether he wants to do an arbitration or whether arbitration is the correct remedy for him. You must see You must evaluate the facts, and you must see what strategy you want to deploy. You may very well have an arbitration agreement in a shareholders agreement, but when you evaluate the facts, you may come to a conclusion that the best kind of strategy to get the solution for the client is oppression and mismanagement before the NCLT. Nothing prevents a party from even looking at options like mediation to resolve disputes. Now, why do you look at these things? Because when a client comes to you, he does not care about getting a piece of paper with the award on it. What he wants is a solution. Think of how to get the client the solution he needs. You may very well need to get that award to get the solution in certain cases. But if you are able to get a solution in a quicker way by doing something like a mediation or by doing an oppression or mismanagement or by evaluating some other options, it is something that the client may want. Short point is, dispute resolution for a matter is not something you pick off a shelf. You have to look at the strategy. You have to consider it and review it on the basis of the facts, on the basis of available evidence and other consideration. It requires time and effort. But don't forget the most important fact. When a client walks into your door, chances are 9 times out of 10, he has exhausted all other remedies. He has come to you because he's in trouble and he needs a solution. So when he comes to you through that door, you are the one shoulder he's relying on. So it is your integrity and your hard work and discipline that he relies on. Now, with that, I'll leave a little bit for my fellow panelists to discuss, but I'm happy to answer any questions that you may have.
Sir, I had a question, but I would like to
please
seek
type your question in
permission
the
from
chat
the
box.
organizers.
Vilma,
If
please
I-
type your questions in the chat box. We are not entertaining individual questions like this. Sorry.
All right.
Thank you, Sahil sir. Now I request each sir to take over the dais. Each sir, you are muted.
Sorry, didn't realize that. Thank you, Samriddhi, and thank you, Delhi University, for giving me the opportunity over here to guide the future generation of lawyers who are going to stand with us at the bar and argue the cases with us and against us. So, welcome to the fraternity, to all the students. Now, obviously, Nandini and Sahil both have covered what arbitration is and why arbitration is a preferred method, and there is very little left for me to speak on that. But I would like to focus on something which is little more different than what Nandini and Sahil have spoken. It's the misconception that I wanted to bring before you students of who needs to learn about arbitration, because a lot of times I see that especially during the guest lectures, we see that only those kind of students appear in the guest lectures who are keen on practicing in the field of arbitration. But that's a misconception. In my opinion, there are 4 kinds of people who need to learn the ins and outs of arbitration thoroughly on practical basis. I mean, you study theory, but the practical aspects is something that all of you need to study. And those 4 kinds of people are: first are the scholars. I mean, those who are looking to study PhD, become professors, teach arbitration in future, or look at enhancing the rule of arbitration law by working on policy or governments. And they are the ones who are going to basically shape the acts and rules of arbitration. I'm sure that some of you here would want to become teachers or professors and teach arbitration as a specialist subjects. And it's very difficult to do that without you having practical hands-on experience in the field of arbitration, because obviously my co-panelist would agree with this, that what you study in law school is seldom what you practice in the courts. So that distinction is very important for you to understand, even if you are going to pursue your career as a scholar. The second category are as clients, I mean, obviously you must, as students, think that none of you are going to be future clients in the field of arbitration. But I mean, obviously that may be true, but it's still important to understand because, first, arbitration is a part of our daily contracts. I mean, the simplest of the contracts, like your partnership with the law firm that you're going to be having, will have an arbitration clause. You should be aware of the do's and don'ts of arbitration, and theory doesn't help there. The second reason is, uh, you need to understand the thought process of a client when you advise him to opt for an arbitration, or when you strategize the arbitration proceedings on behalf of a client. And the thought of a client revolves around time, cost, and outcome of the arbitration proceedings. And these are the three thought processes which go to the root of an arbitration practice. The third category of people are the transactional lawyers, and this is where the major misconception lies. I mean, it's correct that there are people who believe that transaction lawyers need not study arbitration and learn about the practical aspects of arbitration, and it's only the counsels or the litigating lawyers who need to know about this. And that's not true. I mean, the transaction lawyers who need to understand the rules of contract drafting process, and what's inappropriate drafting, what is appropriate drafting, what are the obligations of the party, how to make the arbitrations more predictable, how to make it more efficient, how to make it more cost effective, how to make it expeditious. These are the aspects which the transaction lawyers need to understand when they are drafting the arbitration clause. And there are about 20 to 25 factors in an arbitration clause which determine which way the arbitration is likely to go. I mean, you change the number of arbitrators, and it may determine the predictability of the arbitration. It may determine the cost efficiency of the arbitration. It may determine the speed of the arbitration. So a simple aspect like that, changes the whole dynamics of the arbitration clause. So the transaction lawyers equally need to understand of how the ins and outs of arbitration work. And then the fourth category obviously is the practitioners and the litigators who want as counsels or as arbitrators, or who want to practice as counsels in the courts, and they need to understand. Now, these are the four categories that I had in my. Apart from that, I think the question that remains to be answered is where to begin the career in the arbitration field. Obviously, what Nandini and Sahil have spoken is about you must decide, and I agree with them that whether you want to be in arbitration or whether you want to be in courts. And that distinction, as Sahil correctly mentioned, is slowly and gradually developing in India, and we are all looking forward to having an arbitration bar where we know each other, and we are aware of who practices on this side and who practices in the court, so that those those practices can be developed. But as students, as students who are just clearing out their LLB courses, my suggestion would be to begin with understanding the litigation process, because arbitration will not be really different than litigation, but you need to understand the litigation process, so that when you reach the arbitration and when you start practicing solely in the field of arbitration, there are a lot of small nuances of litigation which helps you understand of how the game is played in arbitration and what strategies are to be made. Obviously, this does not suggest that you should not do arbitration, but there is a misconception that a lot of interns come and say that I want to practice arbitration from day one, and I don't want to learn about litigation, and I don't want to go to the courts, and that's disheartening, because these students sometimes are under the impression that you can become an expert in arbitration without learning the court crafts. But it's I mean, you must realize that it's the court crafts which develops the arbitration. So you're running the cycle the other way around. You need to first learn the court craft in the first few years, and then choose that, yes, I am more interested in arbitration, and start a practice in that direction. But to graduate and say that I'm going to do only arbitrations and nothing else, and go and ask your seniors about which arbitration cases I can go to, and I'm not going to the courts, is something which will not really affect the firm or your seniors, but will affect your career choices and the way you practice arbitration. So these are the things that I thought as a how to begin your career in EDR you should remember. Apart from that, there is in fact a report by the American Bar Association. I think it is McCarb's report, and it basically identifies 10 fundamental. It includes problem solving, negotiations, counseling, communication, legal research. Now it may sound conflicting, but it's not. While I suggested you should start with litigation, but it's at the end of the day arbitration which will allow you to enhance these 10 fundamental. And I suggested you go to that American Bar Association's McCabe's report and look at those 10 fundamental skills. They will you will realize that arbitration is the only practice in which within a span of 2 years you'll be able to develop all the 10 skills, as compared to litigation, which Nandini and Sahil both have mentioned that takes about. So even if you're not going to practice as a counsel, I think going through a few arbitration cases from the start to beginning will help you sharpen those skills as a lawyer. But yeah, I think that's all I had to say about how you can start a career in ADR. And back to you, Samriddhi.
Thank you so much, sir. Thank you for your words. Now I request Abhishek sir to take over the dais.
Hi, Samriddhi. Thank you. Thank you, organizers, for having me. And I think all my fears have come true. Now, all the three accomplished speakers have spoken everything. I have genuinely nothing to say. So I have only learned, and now I'm thinking, what should I say? And before I say anything, there is a caveat. The accomplishments and the achievements of all three speakers is so much that everything I say, if there is any conflict, please listen to them. Please discard everything I say if there is any conflict. Having said that, I will speak, or I will limit myself only to one thing, that is, how is arbitration practice in a tier 2 town? Now, as Ishsa mentioned, I did not get the opportunity to go to courts. I joined a law firm, and the first day I was put into arbitration, which was happening in SIAC, and I was supposed to act as a back office. And after that, it just snowballed into thing. I shifted firms to go into litigation practice. At that firm, some new arbitrations came, and I kept doing arbitrations till I finally quit and came to Lucknow. Once I was in Lucknow, I realized that everything and anything that I had learned, except drafting and how to handle clients, was of no use to me. Here, the judges swore by CPC. Nobody cared about arbitration rules. The rules are what is written in CPC, from inspection to admission denial to everything was by rules of evidence. You have to file a 65B in an arbitration. You have to lead evidence. Every admission denial has to be on a 10 rupee stamp paper for it to be admitted into evidence. So everything changed for me. And one thing I realized, that you cannot, what Ishsa said, and I can't emphasize it enough. You have to be a litigation lawyer, at least for first few years of your life. You cannot jump into arbitration. Arbitration, you specialize few years down the line, but please be into litigation lawyers, and specifically for tier 2 towns, the evolution from litigation lawyers to dispute resolution lawyers has not yet come. We are still litigation lawyers here. We do arbitrations, but we have more litigations. We have to do everything right now because arbitration is yet to mature in smaller towns. For instance, even in Lucknow, which is home to one of the largest expressway and infrastructure SPVs in the country, and a lot of infrastructure is coming here, but still the arbitration is so immature. The practice is still maturing, and therefore you cannot survive on it alone as well. So you'll have to do other practices as well, first. Secondly, there are three things which I have faced in last 2 to 3 years. So I went independent, and then I started making my chamber, and I started getting people, because in COVID, law firms were not hiring that much. So we had the benefit of getting the good crowd in our cities as well. The problem I faced was anyone who wanted to join me had unreal expectations. And I'm talking about first year students or students with 6-7 months of experience. They were talking about third party funding. They wanted to attend conferences. They had more idea about going to 5-star hotels, hot tubbing. Sir, have you heard about hot tubbing? Have you seen the Ashes conference? I'm like, boss, यहाँ पे नहीं मालूम है जज साहब को जहाँ पे बैठे. He will not care about that. He's only worried whether आपने CPC के अंदर fraud read किया है कि नहीं किया. He doesn't care whether you want to call an expert witness. He will take care of it later. You have to move step by step. And that is what I faced was my biggest problem. I worked with 3 or 4 people during these periods. Of course, they have gone back to law firms, to the better postures, better cities. But this is the problem I faced. Now, what are the scope? I have spoken about the expectations. I'll speak about the reality. It is like a normal litigation in tier 2 towns. Even the arbitrations are mostly they are retired judges or district judges, and they take arbitration just like a trial. The good thing is, as Nandini mentioned, it gets over at max by 20 months. I will not say 12 months or 18 months. We apply for 29A, we have to take an extension in tier 2 towns, but it gets over in 20 months. At least the trial part is over. But after that, the commercial court comes, and the commercial courts are mostly vacant. It takes time to go in 34. It's a cumbersome process as such. It has not matured to the level of states with original jurisdiction, such as Bombay or Delhi, or even Calcutta for that matter. However, one thing which is coming up very well in arbitration, and I think my learned seniors missed to mention, is MSME facilitation councils. The arbitration in terms of these MSME arbitrations is a huge thing in small towns. What has happened that under the MSMED Act, now you have a 90 days period for an arbitration reference to be made and it to be decided. Within 90 days, it had to be decided, and the interest rate that these MSMEs get is around 15% to 18%, depending on the 3 times the Reserve Bank rate. So a lot of companies have now started going into MSME arbitration. The docket of MSME Council, at least at Kanpur and Lucknow, is full. They don't have dates for next 1 or 2 years. In fact, that is the situation right now. And now they're outsourcing it to different arbitration institutions. For instance, if I'm not wrong, Delhi MSME Facilitation Council has completely outsourced the entire arbitration to Delhi Arbitration Center, which is at, I think, 30 Hazari Court or Dwarka Court. I'm not too sure. So this is one field which is coming up very well in tier 2 towns. Second, now the small contractors have started to take advice of lawyers on these arbitrations. So there is a dispute management practice. They want these work reports or monthly progress reports to be vetted by lawyers so that they're preparing for arbitrations, for idling, for change of scope, all these public infrastructure things from day one. So they have become a little bit more aware. And lastly, new arbitration centers are opening everywhere. So that's a good thing. But as simple as that, 3 things. You have to be a litigation lawyer for your first 3 or 4 years. Please do not have unreal expectations. It's a normal litigation practice. You will find the same judges as you find in court. In at least in our towns, the lawyers becoming arbitrators is not that common. Although I would love to have Ishsa, I will nominate Ishsa next time I get an opportunity. But we don't have many lawyers as arbitrators here. And thirdly, it's like any other field. You'll have to struggle, but the scope is going great. There is no lack of opportunities or jobs in this field. And I'm hoping that the law firms will start hiring brilliantly again. I'm sure Sahil will be hiring this year a lot. So thank you. That's all I have to say.
Thank you so much, esteemed panelists. So we have collected some questions from our classmates who are studying this paper, from our juniors who have been hearing about this paper, and a couple of questions that have come up in the chat box during the course of the webinar. With the permission of the guest, may I take up those questions? So you can answer those questions depending upon your convenience, and if you want to answer those questions, I'll be sharing my screen.
Questions in the chat box. Don't need to share the screen.
Ma'am, there are many.
Oh, okay.
There are many.
I think, Samriddhi, what would be helpful is if you could just read out the question and just call on whichever panelist you want to answer that. Otherwise, there will be confusion on, how to answer it. Just call upon the panelists to answer whichever question, however.
Sure, ma'am. So the first question is why, I think that has already been addressed, that what is ADR and why it has become so popular recently. And also our esteemed panelists have addressed that it is not a new practice. So the second question that is important is ADR always cost effective? All
Who
of
do
you
you want
have
to
been
answer? Who do you want us to answer?
so difficult to choose, but I think a perspective from all of you would really help, because some of us are living in Delhi, some Sahil sir is from Bombay, but Abhishek sir has been living in Lucknow, so I think we'll have a broader perspective. Because to my knowledge, and some of us who have practiced in arbitration centers, we have seen that arbitrators charge a hefty amount. A certain part of the claim is also given to them. So is ADR actually very cost effective in mediation sometimes when the mutual decision is not decided upon, and even if it is agreed upon and not effected into? So what recourse do we have? Because at the end of the day, we have incurred some amount. So is ADR actually cost effective?
Abhishek, why don't you give your perspective on this?
I don't think it's cost effective. As long as you have retired judges in this field, it will never be cost effective. As simple as that. I have a client whose dispute is 5 lakh rupees and a retired judge gets appointed and he wants 5 lakh rupees as reading fees. He says you will recover it as legal costs. So it doesn't make sense. He's like, these are administrative expenses. So it doesn't make sense for me. I don't think arbitration is very cost effective. MSME based arbitrations are little cost effective, but normal arbitrations I don't believe. As long as there are retired judges there, it will never be cost effective.
You want to talk a little bit about the model fee structure?
That's your perspective. I don't think judges here are following it. They're finding ways. They are charging as administrative charges.
So I think the short point when you look at this is you need to evaluate the contract. If it is a contract for a small amount of money, you may be better placed to go to court. Having said that, you also need to see which are the kinds of courts you have where you can give jurisdiction or where you can confer jurisdiction. The minute you're away from Arbitration Act, you go into jurisdiction under CPC. If you are giving jurisdiction, or if you're in Bombay and for any reason you're before City Civil Court or before the Bombay High Court, it's going to take a little bit of time. If you are in a Tier 2 city, you may very well be able to get a decree in 2, 3, 4 years, which is not very unreasonable. You may also be able to do it in a more cost-efficient manner. Having said that, the onus of proving your case, the onus of doing things will be how court demands they be done and not how an arbitration demands they be done. They are two different things. The concern is correct. Arbitration is becoming expensive and complex. Over the last 3 to 5 years, we have certainly seen a lot of people examine the issue of whether they need an arbitration agreement in a larger contract. There is no other alternative which is as good as arbitration today for larger contracts, for cross-border contracts. In the domestic scene, you may very well be able to give jurisdiction to a court and get it.
Can I just add on that, Sahil and Abhishek? It also depends on which court you are before. I mean, for instance, if you are before the Bombay High Court, today we have a cap of 3 lakhs as the court fees. But if you go before the Delhi High Court, that's not the cap that is there. So, moment that cap changes, your equation changes of whether arbitration is more economical or whether the court litigation is more economical. And this then applies to whether you have to go to Kolkata or whether you have to go to Bangalore, Chennai. So every court you'll have to assess separately of what is the court fees. Where have you chosen as a seat of arbitration, and what is the court fees of that particular court? What is the contract value, as Sahil mentioned? Because if it's of a lower value, you will have to assess or whether you rather pay the court fees based on the percentage which is fixed by that court, or whether you would rather pay to the arbitrator based on per hearings, or whether he would follow the schedule. Then also you have another factor which plays in is, and this is a trend which is kicked in very recently. Obviously, the Bombay High Court had started this practice way back in 2013-14 with Justice Karnawala. But the Delhi High Court has just started that practice of appointing younger lawyers as arbitrators to make the arbitrations more cost effective for smaller contracts. So, as Abhishek mentioned, so far as retired judges are appointed in smaller contracts, it's going to be something which is not feasible. And that's where the alternative comes in to appoint the younger arbitrators, people who have experience as arbitrators or as counsels practicing in arbitrations in Bombay and Delhi at least. And that's something which is not kicked in other jurisdictions as yet, especially in Madhya Pradesh, in Punjab. All these places are still not recognized, appointing somebody younger. They are empaneled with younger arbitrators, but the appointments are still with the retired judges because of the conventional thought that follows with the judges who are still presiding there. But that will change, and that should then eventually make it more cost effective.
Thank you so much, sir. The next question is, are big law firms restricted to arbitration only? Since we have two people from law firms, Sahil sir and Nandini ma'am, I request you to address this question.
Nandini, ladies first.
We are living in a world of feminism and equality these days. No, I don't think so at all. There might be some partners in a law firm who want to practice only arbitration, and that's obviously encouraged because we want to have an arbitration bar. But that doesn't mean that the law firms are only looking. In India, anywhere in the world, I think the court systems are thriving and they are an essential part of the judiciary. You can't really do away. So if it's a full service law firm, you can't get away from having a litigation practice. So every law firm will at least have a litigation practice for an arbitration one also.
So there are many methods of ADR, the many ways of alternate dispute resolution like mediation, negotiation, conciliation. So are big law firms eyeing those areas also, or are they primarily focused on arbitration? That is the question.
See, mediation is definitely being encouraged everywhere. All high courts are now coming up with mediation centers. The problem with mediation is that because it's not binding, a lot of the people who have nothing, as I said, usually one side, if one side has nothing to lose, then they don't want to compromise. Mediation is very effective. It should be encouraged, and I know a lot of law firm partners who are taking up mediation in a big way. They spend a considerable amount of time training in mediation and then mediating cases. It's become mainstream yet by any standard, but it's on the rise for sure. Sahil, if you have a different view, please.
Not at all. In fact, I myself have gone in for the mediation training. I am a trained mediator. When a client walks into the door, you don't know whether you are going to initiate an arbitration. You don't know whether you're going to be initiating a court case or a regulatory proceeding or even a criminal case. It could be a mixture or a mix and match of all of the above also. So to answer your question directly, as a law firm, you cannot just focus on arbitration. You have to do all kinds of litigations because that is something your client will need. What your client needs is something super specialized. The second part, the mediation component, very, very critical, and it is something that we are seeing a lot of clients demand for it. They are demanding for trained mediators to come in and help them bridge the gap, because everybody realizes that litigation, arbitration are all going to be very expensive and time consuming. A faster settlement and to help somebody arrive at a settlement, a mediated settlement is looked upon very, very favorably.
Thank you so much, sir. There is one more question. Talking about the firms, how is the area of practice dispute resolution different from other core areas like general corporate, MA, taxation? Could you please apprise us of the nitty-gritty of the claim?
So, Nandini, you want to take a shot at this?
I think this is a mean, it's like a very, very vastly different practice. The concept of general practitioners was there earlier on, where the same practitioners did corporate, did litigation, did real estate, did tax, and all of it together. And of course, the practices itself, all of it. Now the practices are different, and there are differences in all of this because of the complexities that have come in, the specialities that have needed. The M&A or corporate practice, as we call it, is largely where contracts are built, where parties are in their honeymoon phase, as we call it. Everything is good. Two people are coming together, and dispute is really the divorce phase of the situation, as we say in the fraternity. That it's the last leg. So corporate is really the first leg. Disputes is the last leg. Real estate and tax work simultaneously along with corporate. Real estate practice really has drafting, conveyances, sale deeds, licenses, and it's a niche practice. There were a lot of firms that just did real estate in old in cities like Bombay and Calcutta. We had law firms just doing real estate. It was a very specialized niche thing, but now I think most law firms have a vertical which do real estate specially. Tax practice again has become very specific. There are in fact a further divergence in indirect tax practice and tax practice. This is largely advisory. Of course, you do have some amount of tribunal practice in that, where you go and present your cases to the tribunal, whether it's for GST or whether it's the income tax tribunal, and so all of these kind of things. But largely, it's quite different. I would say there are very, very different sort of like a corporate practice can essentially be done work from home kind of thing. If there's like, the corporate team hardly to be physically present if there is a problem like COVID happening. Litigation, if courts are functioning, you need to be in the court if it's not virtual. So that's really a ground level reality, but the practices are very different. You can't sort of, and also one thing you must keep in mind, if you're going in for a corporate practice, it will also need a lot of regulatory understanding, because you'll have to look at SEBI, FEMA, competition law, all of these things. So your regulatory advisory comes into play with corporate practice. Litigation, really, it depends on what the nature of the dispute is. You'll have to pick up that particular problem, whether it's a wildlife issue or a FEMA issue or a simple breach of contract or a divorce matter, as and when the problem comes to you.
And just to add to what Nandini said, while the two practice areas are completely different in how they operate and the skill sets needed and the outlook needed, simply because the world is becoming so much more sophisticated and complex, when there is an M&A dispute that comes up, members of a lit team will often work with members of the M&A team to look at how a document is to be, where they are able to pick holes in it, and how they are able to exploit it for the purpose of their litigation. So while there are differences, you are seeing members of the team work together very, very extensively. You are seeing members of the litigation team pick up industry expertise. They know how industries work. They know how documents in a particular industry are drafted. So therefore, you are seeing more and more interplay between these kinds of areas.
Thank you so much, sir. Thank you so much, ma'am. We have a lot of questions still, so maybe I'll share a questionnaire later, which can be filled by our esteemed panelists. They still are sending me a lot of questions, but due to paucity of time.
Can I just take one thing? There was an interesting question that was sent in to us earlier. I just wanted to, and I think Abhishek mentioned it, so it came into my mind. Abhishek mentioned that in the tier 2 cities, the arbitrations are largely governed by CPC, the provisions of CPC. In the questions that you had circulated earlier, there was a very interesting question on evidence. in arbitration. And I think it would be the right person placed to maybe discuss this for 2-3 minutes. But I would just like to address it for half a minute by saying that arbitration actually is also a very good place to thrash out your litigation or your dispute, because strict rules of procedure under CPC are not practicable. Yes, the broad principles of evidence will be needed for an award to stand the scrutiny of a court challenge, but you do away with a lot of the procedural things which take time, money, and a lot of effort on part of the lawyer as well as the litigant. आपको हर चीज को plead नहीं करना, you don't have to do the stamping and the notary in the exact ways, especially if you're doing a cross-border, which is a larger thing. But in a cross-border thing, if evidence is coming in from a person sitting in France or any other country, you would have to notarized, apostilled, which takes their own time, and in short timings in court, you'll get delayed for sure. In arbitrations, you get exemption for all of this if you request for it, if the arbitrator is willing. There's no compulsion. So in a recent arbitration, which was cross-border, we said that the parties will just sign it, and it will be sent across, and we'll work on scanned copies, and physical copies can follow. There was no need of notary, there was no need of apostilling, which saved the client so much cost, so much time. So I think that evidence part, I would like Ish to speak on. It's a very interesting thing. Ish, may I just bother you for this for a minute?
Sure, Nandini, that's something which, in fact, comes up for debate even today during arbitrations. What happens is there is a clear case law which suggests that the CPC and the Evidence Act does not apply. Obviously, there is some debate over whether the substantive portion of the Evidence Act would apply and whether the procedural part of the Evidence Act can be exempted by the arbitrators. But keeping that aside, as an arbitrator, at least in my experience, what I have tried to do is keep on to those requirements, because asking for signatures again and again is not required. Applications can be made by the lawyers because it's not that the party is going to dispute. The parties are generally present for the arbitration proceedings, or at least the in-house legal counsels are present. It's not without their consent that the lawyers are filing the application. The formality to have an affidavit and an application separately, like the courts, they have their interim applications or their notice of motions, like it was there earlier, and then having an affidavit in support separately, having a statement of facts, a statement of admission and denial. All those things, just take time, not only of the arbitrator, but also take a lot of time of the firms that are working for those clients, because drafting those takes a hell of a time for the associates, and it has no value. I mean, in true sense, to adjudicate the disputes and to come to a finding whether whether a particular party is right, not right. I don't require those things, and it's seldom come to consideration whether it's been signed by the parties or not. It's only when the other side disputes it, in which case the technical requirement can be complied simultaneously while the arbitration proceedings are going on. Another thing apart from the evidence has been that there is a lot of requirement in the court that how the evidence, in what order it has to be filed. Obviously, now we have the Commercial Courts Act where the evidence filing is to be done by both parties simultaneously. But in the ordinary suits, that's still not the requirement. And we still traditionally follow in the courts that the plaintiff files the evidence first, he files the list of witnesses first, and then we finish the cross-examination, discharge the witnesses, close their evidence, and then we move on to the defendants to file their evidence. And that bloody hell takes a lot of time, trust me. In arbitrations, what fortunately we have is the discretion given to the arbitrators to direct that all these filings have to be done simultaneously. So all the witnesses' evidence is filed simultaneously by both the parties. So we have about, say, 2 witnesses from the claimant side and 3 witnesses from the respondents. I need not give separate time limits of 2 weeks or 4 weeks to file each of these evidences. I've given a period of 6 weeks, and I have all the 5 affidavits of evidence ready in front of me. I have all the compilation of documents which are there with me, and we can then begin the process. So I have literally saved on about 4 weeks for each of those witnesses. Now, the advantage of doing this is when I come to the admission and denial of documents, all these documents can be marked on the first day and we can proceed with the cross-examination. I need not then separately wait for the witnesses to be confronted with documents and then dictate of why that document is to be exhibited, and then they have 10,000 objections going on. So all that procedures during the trial is eliminated. We have documents which are admitted by both parties. We can exempt 65B certificates wherever these are admitted facts. Where there are disputes over 65B certificate, as an arbitrator, I have many times asked parties to just demonstrate on their email account that this email exists. When there is serious objection, I mean, I just look at the email and I know that it exists. I record that in the minutes and it's done away with. I don't require a separate 65B certificate. No adjournments are required. So this entire leeway that is available to the arbitrators to not follow the procedure under CPC and in the Evidence Act expedites the process. I mean, this brings us the ability to finish the trial within a period of 6 to 8 months, which generally is not available in the courts. I mean, they're compelled to follow those procedures, and obviously when the appeals are filed, if those procedures are not followed, those decrees can be overturned because those procedures are not followed. In terms of the awards which are passed, despite not following the procedures, I have rarely seen that the award is overturned because the procedure was not strictly followed. The awards normally get overturned because equal opportunity is not given, or there has been some foul play. It never gets overturned because the arbitrator did not take the evidence in a particular order, or exempted the 65B certificate, or the affidavits were not signed, or those technical difficulties are not there when an award is challenged. I mean, that's what I feel. I mean, I hope I have answered your question, Nandini, but yeah, this is generally what I have felt as an arbitrator for quite some time.
So just to give them a perspective on, because it was a very interesting question that was asked prior to the circulated, and I thought it was good to have touched upon that.
Thank you, ma'am. Thank you for this interesting aspect. I'm really thankful to all the esteemed guests who have joined us today at such a short notice. It was actually a dream to have all the panelists today that we have in front of us, especially given the short notice and the way we have functioned. But I'm really thankful to all the panelists, along with the teacher faculty members who have blessed us. Our professor in charge, Dr. Mahavir Singh Kalan, he has always blessed us. And always given us freedom to organize whatever we want to, as long as it is in our favor to gain as much knowledge as possible. Then I'm very thankful to our teacher convener, Dr. Parikshit Rohi sir. Sir has always been very kind to us. So we just discussed the idea with him that we want to have something on ADR because we have its paper. He said, yes, go ahead. Even though he could not make it and he was not available on this day, he still allowed us to go ahead because we knew it was very important for us and what it meant to us as a team. I am really thankful to my team. They are just, most of them are in first year, second year. I have not even met them. So I was appointed student convener a couple of weeks back. We have met online. We have discussed everything online. They reached out to the panelists on their own. They had no idea. So I'm really thankful to my team for having they have made this webinar actually possible. Otherwise, it would not have been. I'm really thankful to Ashwini sir who took our time. He was busy studying, so we requested him if he could come to the webinar and address the gathering, which we did. I'm really thankful to him. And then we have our professor, Dr. Ajay Sunavne sir. Sir teaches us public international law and other subjects. He's very good teacher. He has joined us in the capacity to help us bring this event live stream. I'll share the link with you all. So this event has been live streamed all the time. Very, very thank you so much to all the participants for joining us.
I just asked for retired judges not to be arbitrators on something which will be on YouTube forever.
Yes.
It's good to
This is going to be held against you, my friend.
Good.
I wish I could ask you guys for refreshments, which is the general practice of law faculty known for its hospitality. But we are all sitting in different cities. Sahil sir is sitting in Mumbai. Nandini ma'am is sitting in Kolkata, which is my hometown. Abhishek sir in Lucknow and Ish sir in Delhi, maybe. Sir, are you from Delhi?
I'm from everywhere right now.
You are in?
I'm primarily from Bombay, but yeah, I keep traveling to Delhi half the time.
So you are all most welcome to our Faculty of Law to meet us. We would be really happy to have an offline session with you all. Thank you so much for joining us. Thank you.
Thank you.
Thank you, Sahil. Thank you.
Thanks a lot, guys. Bye-bye. Have a good
Thank
evening.
you. Bye.
Please place us also. Thank you so much, man.
Guys, a very good job.
प्लेसमेंट की बात हो गई आपने
Everyone.